Good morning, everyone. Well, we've had a good and substantive couple of days, I think. Now we're going to spend a little time with our fiduciary counsel, Ashley Dunning, who's going to run us through our fiduciary training, which is, as we all know, essential for us to be able to remain compliant with the governance requirements around our fiduciary duty. And so I'm going to turn it over to Matt Jacobs, our general counsel, in just one moment. Before I do, I just want to note that there's not going to be a closed session today, so everyone's going to get out early, and that please do fill out your evaluations. I haven't done them all yet myself, but since I'm letting you out early, maybe you can stick around for 5 minutes and fill them out before you leave. All right. With that, I'll turn it over to you, Matt.
Very good. Good morning, everybody, and welcome to this year's fiduciary training. Kind of disappointing to see the weak crowd out here. There's no fresh water, you know, the cooler. All right. It's like we don't get no respect. But it will be led by Ashley, as Priya just stated. For new members, I'm sure you already know this, but Ashley has been the board's and CalPERS' fiduciary counsel since about August of 2016. The last few years, the fiduciary training has focused on the fiduciary basics, the duty of care, the duty of loyalty, the Bagley-Keene Open Meeting Act, the Public Records Act. This year, the focus will be on fiduciary challenges in an evolving legal landscape, and Ashley can explain what that is in just a moment. We would note that both of us welcome and encourage. I don't think that this board needs any encouragement on this, but welcome and encourage any questions that you may have along the way. And I would note, I don't know if Ashley noticed this, but her PowerPoint this year is a mere 25 slides as opposed to last year's 75 slides. So that may give us time to shoehorn in a little discussion. So with that, I'll turn it over to Ashley. Thank you.
Thank you, Matt, and thank you, board. It's a great pleasure to be here. As Matt said, I'll be focusing on fiduciary challenges that we're all facing in the public retirement world these days. And although I only have 25 slides, they are chock full of material. So I'm hoping we'll have plenty of time for all of them. I think we will. But first, I'd like to set the stage here and just identify at a high level what is evolving in the legal landscape around public retirement. And then I'll get into some detail on each of these. And many of them, probably all of them, will be very familiar to you. So for starters, we know of the legislative efforts in California and nationally to mandate lower or more restrictive retirement benefits in California. That took the form of PEPRA, primarily, the Public Employee Pension Reform Act of 2013. But that's been going on throughout the country. We have ensuing litigation, and we have some court decisions. Some of them upholding some of those efforts, and most recently one not upholding the effort, and we'll talk about that. On the investment side, as the CalPERS Board is very aware and has been involved in some of the legislative efforts to achieve greater transparency into your fees, expenses, your returns on alternative investment funds in which you invest. And then there's some pushback, and there's some rejection of pension plans by the investors, by certain managers of those types of terms. And you as retirement boards are seeking to balance the various interests involved in all of these considerations to run a successful investment program. Another aspect to this evolving legal landscape is you have pretty active grand juries that are focusing on public retirement in a lot of local jurisdictions, and many of them are critiquing various aspects of public retirement plans, whether it's the funding or the provision of benefits. And some of these court cases and decisions that I mentioned and that we'll talk about a little bit more have actually referred to grand jury findings, which is not something that we've necessarily seen before. And then retirement boards across the country, and certainly in California, are seeking to address funding challenges. If that wasn't enough, we have more. We have continuing pressure to meet your investment return assumptions, greater emphasis on private investment market allocations and transactions, sometimes getting into investment classes or asset classes that are considered more risky but offer potentially greater returns. And then in some arenas, more tolerance for less limited partner friendly terms. So now turning to litigation. I'm going to give you a very high-level sweep of pending litigation in California, and then I'll talk very briefly about cases in 3 other states involving public pension plans. And I've categorized these cases into different types of challenges that we're seeing. The first type of challenge I've identified is those that are trying to go back to the core or back to the inception of a pension benefit, the original grant, and challenge how it was originally granted as a basis to try to unwind the whole thing. And we have 2 cases that I'm aware of going on right now about that. One is right here in Sonoma County, the Luke litigation, where an in pro per plaintiff is challenging the provision of enhanced benefits to members on the grounds that Government Code Section 7507 wasn't complied with. That's the provision that says 2 weeks prior to providing a benefit enhancement, an actuarial report needs to be publicly provided to identify the cost of that enhancement. That case has been dismissed on demur the first time, but the plaintiff has been given an opportunity to amend, so it's still proceeding. Brown is a similar case, also dismissed on demur based on statute of limitations grounds, but given an opportunity to amend, and he's now brought in all of the unions as he was required to do. So that case is moving along. The second type of case are those that are challenging the constitutionality of some of these PEPR changes that impact the future benefit accrual rights of current members, so legacy or classic members. And this board obviously will be very familiar with the CAL FIRE case involving airtime, which is before the Supreme Court right now. There's the MAPE, or now the Marin case, which is dealing with standby type pay items and whether or not those can lawfully be excluded from future retirement benefit determinations. That's been accepted for review by the Supreme Court. And then the coordinated proceedings, which is the one that recently had a decision come down by the First District Court of Appeal, concluding that the PEPR changes were unconstitutional. And that one is very much pending because it's unclear whether the Supreme Court has accepted review of that or not, so we're sort of in the midst. And then the third type of legal challenge these days relates to the funding of the plans and the way in which plans are managing their reserves. In the CalPERS statutes, I believe it's referred to primarily as surplus funds, funds in excess of your assumed rate of return. In the county systems, it's referred to either that way or as so-called excess earnings. The SRBR is a supplemental retiree benefit reserve that's permitted for some of the county systems that uses excess earnings to fund supplemental retiree benefits. The O'Neill case is a piece of litigation where the retirement board transferred some non-valuation funds out of that non-valuation reserve into a valuation reserve and resulted in lowering the employer contribution rate, and the challenge to that is that it was a breach of their fiduciary duty of loyalty to members. And that's a case that originally the retirement board won in the trial court, then they lost in the Court of Appeal, was remanded, won again in the trial court, went back to the Court of Appeal, lost again in the Court of Appeal. Now they're going to trial. Miller is a case involving San Joaquin Serra, and that is another county system. That's a case involving their post-Ventura retirement settlement agreement, where, again, reserves were to be allocated in a particular way, and there's a question now about whether they were allocated correctly. And then finally, we have challenges to board's determinations of comp earnable and pensionable comp. This is a case that involved overtime and whether certain type of scheduled overtime or whether it was scheduled overtime was required to be included. That's a case that we won in the trial court. Even more litigation. So as I mentioned earlier this morning offhand, there is a lot of litigation going on these days on these issues. You may be familiar with the felony forfeiture litigation. That also involves a PEPRA provision that permits individuals who've been convicted of a felony based on activities connected with their work upon that conviction, to have a portion of or all of their retirement allowance taken away and provided a return of their contributions without interest for that period of time where they were committing the felony on the job, basically. And there are 4 pending cases right now challenging the constitutionality of that statute. 2 of them are on appeal. 2 of them are at the Superior Court. Hipshire is the one that's most likely to be decided first. All of the cases at the trial court level have upheld the constitutionality of the statute. Notably, they're using a very different analysis than was used in the recent Alameda County DSA case. Challenges to changed or closed defined benefit plan. This is a totally different type of challenge. This challenges the way in which the San Diego City retirement system was closed and whether that violated collective bargaining rules because of the mayor's involvement in that effort, that initiative effort. And then finally, there are challenges. Another type of challenge is to a retirement board's interpretation of laws applicable to it, charter provisions, in the face of a Court of Appeal determination that part of a new charter provision was unconstitutional. And that's before the Court of Appeal right now. And then we have some very high-profile examples of litigation on some of these issues in 3 other cases, 3 other states. So the Supreme Court of Illinois issued a decision called In Re Pension Reform that in which the court analyzed their pension protection clause. This is a clause of their Constitution that's it's like the contract clause in the California Constitution, but it's specific to pensions. And based on that pension protection clause, the court said that the legislature's efforts to, or changes to the rules, to the pension benefits provided to current members were unconstitutional. So it wiped out those changes. On the other hand, you have the court in Oregon, the Supreme Court in Oregon, in the Morrow case, which revisited its version of the California rule and said, in fact, the contract that is enforceable is that which is earned on a daily basis. And so you're entitled to what you've earned, but you're not entitled to continue to accrue on the same terms, which is basically the ERISA rule. And then you get to Colorado, where you have the Justice case, and that was the Supreme Court saying, with respect to COLAs, the legislature never intended to bind itself to not be able to change the terms of the COLA. So you see a lot of different ways in which this issue of constitutionally protected retirement benefits is addressed in different states. And some of it is based on the jurisprudence of those states which will be inapplicable here. Others have a few more ties. So what is a board to do in this world of all these competing demands and arguments and issues? The title here actually probably should say legislation, because this first slide is on what legislation, what are you supposed to do as a board at the outset if, say, your legislature is considering PEPRA 2 or something like that. And there are a variety of different positions that boards will properly take depending upon the issue. And you do have a bit of discretion and authority to consider, to exercise your best judgment to consider how you want to manage that process. Yes?
Aren't a lot of the ways these court decisions are swaying is depending on the language written in the respective state's constitution, correct? Or not?
To some degree.
I was just
the
curious
Oregon,
as to what makes one jurisdiction go one way and another go another, like, and how does California's laws or constitution distinguish it? So we just have a better framework.
There are cases like the Oregon case where there is a pension protection clause, and nevertheless the court reached a different conclusion, which was less protective of future accrual rights than the Illinois court did. So the pension protection, the existence of a pension protection clause is not an end-all. It doesn't necessarily answer the question. I think that one needs to look at the jurisprudence of each state to see how and why it's developed in the way it has. And pensions in many states, very few now, but originally were viewed a little bit like Social Security, more like a gratuity. And then the protections began to, the analysis that resulted in the courts concluding that the contracts clause of the U.S. or the state and the state constitution provided more protection, developed in varying levels of strength. In California, the courts have been quite protective over the years of not only what's been accrued, but also the right to continue to accrue under those same general principles.
And do you see that changing one way or the other?
Well, that's really what's before the Supreme Court right now. So you have the circumstance of the CAL FIRE case,
right,
where the analysis of the Court of Appeal was the legislature never intended to bind itself to provide airtime purchase rights forever. And in the context of that particular type of benefit, which was supposed to be cost neutral, maybe there's a distinction. So
what I'm interested in, because you know as well as I do, a lot of cases are decided on economics. And I'm curious if you think that the current economics will impact the court in one direction or another, meaning the unfunded liability.
Okay, here's what I'll say. Number one, the Marin decision looked at the economics on its own. The court did. That was not an argument the parties had made. On the one hand, so that's one model. The reality of those cases, though, is that you're not talking about benefits that move the needle. So, yeah. And we have a very careful Supreme Court, and they'll get that difference. So whether that ends up mattering, whether that ends up mattering or not, is to be seen. But that's not what these cases are about. These cases are not about whether CalPERS can pay benefits if airtime is provided or not. That would be ludicrous. But they are about the plan and the successful operation of the plan and what that means. And I think that's what the Supreme Court's going to decide. What does it mean to be able to make changes that enhance the successful operation of the plan? Is that only a funded status issue, or does that also speak to things like making sure that the benefits that are paid reasonably reflect what was earned in regular salary during one's employment? I think they're really different questions. So when this legislation comes along, the retirement boards can simply be sort of act as the administrator who implements the legislation and ordinance, potentially even be a trusted provider of information to the legislature about what works, what doesn't work, why certain proposals are not prudent, not appropriate, others might be less objectionable. Or boards may decide from a fiduciary perspective to just take a back seat. You're the administrator of the plan, yes, you're the trustee, but your role is to administer what's been adopted when it's been adopted. Or you may decide that you want to be an advocate as to certain types of reforms, either for or against them. There are policy considerations in all of that, and certainly there are fiduciary considerations, overall best interest of your members and beneficiaries. But as we've talked about in the more sort of fundamental fiduciary duty discussion, the interest of your members are cross-cutting. You have active members who joined yesterday who are going to be receiving certain level of benefits for certain level of contributions. You have retirees who are expecting to get their COLA but are no longer paying contributions. Really different considerations, and you have a fiduciary duty to all of them. To the overall best interest of all of them. Exclusive benefit issues, you're only to use trust funds for trust purposes. So you have to be careful about the expenditure of funds on other things. In litigation, so specifically, what is your role? Are you a necessary party to litigation? What if a big lawsuit is litigated, resolved, and you're not a party to it? So you're technically not officially bound, but you have to live by whatever the decision is. Is that a good place to be or not? Once you're in the litigation, are you just going to sit back and take a passive role? That might be appropriate in some circumstances, might not be what you're inclined to do in others. Do you turn around and become an advocate? Do you think the plaintiffs have a better argument? And CalPERS has taken that position in cases in the past. Or do you want to defend how you've administered the plan because you think it's lawful and you want to explain to the court why you believe it's lawful? There's a member education component of it. I mentioned the necessary party. If you're not already in the case, do you intervene? Do you interject yourself? Maybe, maybe not. Or do you go completely on the offensive and do you file a complaint for declaratory relief to try to state the case as you think it should be presented to the court and get some guidance? And then what do you do in the context of this pending dispute? Are there areas where you can adopt policies, you can adopt rules that maybe clarify how you believe the proper administration of the plan works? And I've seen that by a lot of different boards. Boards do that successfully, to be able to articulate in your own policy what you're doing and why you're doing it, and sometimes that is afforded deference. There's an interesting comment in the most recently published vested rights decision, which is that, well, deference is not to be afforded to the local retirement boards, only due consideration. Perhaps the CalPERS board gets more deference because you're a state agency, so I guess that was a win for you. So in any event, you should be given some deference and certainly some due consideration, particularly in areas where you have quite a bit of plenary authority as well as exclusive responsibility. And we'll talk about that a little bit more later in the presentation. There may be ambiguities in the law that you can proactively seek to interpret. Again, you may not get a whole lot of deference from courts. Once it goes to the court, they look at these things de novo, which means fresh. But you can take a stab at it because you are the experts in this area, and in some instances, courts have really respected that. And then we have this balance of obligations between statutory mandates and contractual obligations, and you've seen that play out in this most recent case where one of the issues had to do with the impact of class action settlement agreements that provide benefits that are no longer permitted to be provided by statute. And in that case, the court has said, at least to date, that equitable estoppel applies to require the boards to follow those contracts, notwithstanding the legislative changes. Yes.
Ms. Yee, go ahead.
So, Ashley, as you're going through these different scenarios about the role of the board, I can't help but to think, just asking for some clarification with respect to what the role of the board would be if there were a statewide initiative that looked to curb or limit or eliminate benefits. Are those roles different in that context?
Yes, because a statewide initiative implicates different laws, and you can't use public funds to influence the electorate. So, yeah, you have more flexibility with respect to legislation enacted by the legislature as opposed to that presented to the electorate. Good question. I thought I got into the nuances, but there are some additional nuances that are very important here. So another issue in terms of fiduciary duty and this litigation is, and your role as a board and as an organization, is who sets or decides or sets the strategy and the tone. In normal litigation, not involving public agencies with high stakes ramifications, your counsel sets the litigation strategy. Not so obvious in the context of these types of cases. And you will have closed sessions to discuss exactly that. Recognizing that as a board, you're a multi-member board whose composition will change over time, likely during the duration of some of these lawsuits, and that your executive staff, including your general counsel, most importantly, but certainly your CEO, are going to be doing the day-to-day discussion, having the day-to-day discussions with your litigation counsel if it's outside litigation counsel. So I've just identified on this slide the various different actors and how they all need to the interplay between them, so you can think about these issues as you assess what steps are being taken or should be taken. And your decisions may change over the course of a piece of litigation. You may have one position before the trial court where, because of the result in the trial court or the result in other cases that are going on that you're watching, you have a different perspective on it. And how do you incorporate that into your discussions with your counsel? Yes.
Ms. Taylor.
Thank you. Your last bullet point there, are there any required recusals? What would constitute a recusal for a board member?
If there were a personal financial interest that a board member had that was unique to that board member. So not, and this is something that was resolved in the Lexon case, the Supreme Court Lexon case, not a question of, say, whether a benefit formula is legal that applies to all of your general members.
Okay.
That is something that was considered that falls within the public services generally provided exception to Government Code Section 1090. So you wouldn't have you shouldn't have be deemed to have a personal financial interest that disqualifies you. But if there's something more unique to you, maybe it's a special type of benefit that only a few people get, only the executives get, or that type of thing. There may be other types of litigation that aren't the type that we're discussing right now that involve an organization that you have an interest in. And if what you really need to think about is, do I have a personal financial interest? And if I do, is there a reason I'm allowed to participate in this anyway? And that's something to talk with your general counsel about. Or do I have an institutional conflict? Do I wear two hats so that I am on both sides of this litigation? It's one entity against the other entity, and I have an official role with both of them. That may create an issue. But again, that's one you need to talk with your general counsel about. So we use this word fiduciary. What do we mean? What are we talking about? Like the two prongs of fiduciary duty, which most of you are very familiar with, or probably all of you at this point. Duty of prudence. So think about the subject matter of the litigation and how that impacts the decision making you may be having around it. It may be a type of, if we're talking about benefit or pension reform, you may have one view about felony forfeiture rules, and you may have a different view about formula changes. So it matters to think about that. There isn't just one answer that applies to all types of litigation. Same thing with your duty of loyalty to your members and beneficiaries. Although, remember, in the felony forfeiture context, you owe a duty of loyalty to all of your members. Now, it's an overall duty of loyalty to all of your members, so there will be circumstances where you have a member who's going to be disadvantaged as a result of a piece of litigation. That doesn't mean you have to side with that member at all, but it's something to think about. You have a role as administrator of the plan. We're familiar with the other constitutional provision, Article 3, Section 3.5, which says you, as an agency, as a public agency, don't have the authority to deem a statute to be unconstitutional. So once it's in your plan, you have to administer it unless and until a court tells you otherwise. Finally, what is your record of action on this topic, and does it matter? Sometimes it really matters, and we're seeing that in the O'Neill situation, which again is the case that involved the use of reserves and the transfer of reserves from a non-valuation account to a valuation account. That record needs to be awfully good to support the conclusion that the board was looking out for the overall best interest of its members and beneficiaries, because now they have to go to trial on it. So it's something to think about.
So when you say that the record has to be good, you mean that the rationale for making a decision has to be clearly articulated on the record?
Precisely, and reflected either in board policies, resolutions, rules, or at minimum in minutes. And for some of the local agencies, they might have a different kind of minutes than CalPERS. CalPERS has more rigorous requirements in terms of certain rulemaking that you do. And Matt, yeah, please.
Doesn't it also, as part of that, require that there be evidence, factual evidence behind the policy?
Yeah, that's a great point. One very valuable tool you have in terms of establishing your record is that you and your executive staff compiles your agenda backup. And it is that agenda backup that is so critical to make sure provides strong support for whatever decision the board makes. I mean, that's one of the realities and the requirements of the laws that bind you as well. You can't have reached a decision as a board until you get here. So your staff doesn't know what decision you're going to make until you get here, by definition. But your agenda backup needs to provide you with enough information that you collectively as a board can make a prudent determination that's consistent with your duty of loyalty, hopefully regardless of which way you come out. Now, that's a challenge, of course, because there will sometimes be a range of options presented. But your staff works very hard to make sure that the options that are presented to you fall within a reasonable range that, in their judgment, they've concluded meet those tests. Right. We talk about this sometimes in the context of recommendations that you get from experts. This is a bit of a side note, but it is important to recognize that, and it's part of my Fiduciary Duty 101, when you are provided a recommendation from an expert on a topic within their area of expertise, for example, your actuary or your CIO on investments, you are to listen and to duly consider those recommendations. And if you're not a rubber stamp for them, on the other hand, if you want to do something different from those recommendations, whatever that different thing is, needs to be grounded in the science and the art that is being presented to you. So it shouldn't be simply because you don't want to, or you think that it's, for an undefined reason, you think it's a bad idea, or for an unfiduciarily sound reason, you want to do something else.
Which is why, excuse me, if the board or a board member or several board members think that there isn't sufficient information provided, then we could defer a decision.
Yes.
Right. So instead of if the record's doesn't have enough substance behind it.
That's a great point. Absolutely. And you are co-fiduciaries to one another. So as you have these discussions, it's important to bring each other back to the key principles that guide your decision making. Again, not suggesting that you're all going to see these issues with the same lens, although it has to be that fiduciary lens. You may make different judgment calls, but you should be operating within the same understanding of the legal framework that governs you. All right, so now turning to investments. Same principles, duty of prudence. They apply slightly differently here because you're talking about terms. Your duty of loyalty to members and beneficiaries. What is that duty? That duty is to make sure that you can pay their promised benefits. Yes.
Ms. Brown.
I'm sorry, I don't mean to call on
No,
speakers.
that's okay.
I defer to the chair.
No, that's okay. So, I looked at this duty of prudence regarding terms. And so are we talking about terms in the agreements we sign with general partners or private equity terms? Because I go back to page 5, and you talk about the changing legal landscape, and we're supposed to have increased tolerance, you say, for less LP-friendly terms. So I assume that means worse terms. And then here, we're supposed to have a duty of prudence regarding terms, except my understanding is those agreements are secret because they're trade secrets, so we don't get to see the terms a lot of times. That's my understanding. So I'm just wondering, how do we have our fiduciary duty regarding the terms when we don't get to see them?
So there was a lot packed into that question. Let me see if I can address a couple of components of it. The first point is on slide 5 when I say increased tolerance for less LP-friendly terms. I'm not suggesting that's a good thing. What I'm saying is that is a reality that I understand exists, particularly in certain asset classes. And I'm basing that on my partner, who's very close to all of this in terms of the investment side of it, what she's seeing. The fiduciary duty applies to the big picture. Is this a prudent investment under all of these circumstances? One component of which is terms. Another component of which is this a great fund for us to get into? And are we willing to sacrifice on some terms in order to be able to get into the fund? That's the analysis. Now, when one says we don't get to see the terms, we CalPERS see the terms. Those are negotiated. You have delegated some of that authority to your trusted staff, and that is fundamental to that relationship, that those terms be negotiated in a way that your staff can say to you, we believe these terms are prudent, and here's why. And if there are reasons why the document itself is not to be shared more broadly, those may be to protect the value of your investment as well, because you won't get into a particular fund if those terms will be specifically provided to the full board. And that's an assessment that needs to be made. This actually leads to another really important point, which is confidentiality. So there will be certain things that are confidential to those who are negotiating on your behalf, including your general counsel and your CIO, presumably. There are others that are confidential to the board. And once you're in that closed session and you're talking about these investments and the terms, you are under a legal obligation to maintain that confidence. And that is part of your duty of prudence and loyalty as well, because number one, you got to follow the law. Number two, it's a misdemeanor if you don't. Number three, you're potentially undermining the value of both that investment and potentially other activities of CalPERS if that information gets out in terms of the impact on the market and that sort of thing. So that's a sort of long-winded answer to a multi-part question. I hope I got to all of your questions, but if there's a part of it I haven't answered, I'm happy to do a follow-up. Okay.
Thank you.
All right, so duty of loyalty, delegation to manager with or without assumption of fiduciary responsibilities. Now, you have fiduciary responsibilities, you as a board have fiduciary responsibilities imposed by law as a result of your positions as trustees. Whenever you are delegating some aspect of your decision-making authority to another, you are both retaining the ultimate responsibility and requiring another person, another entity, to act in part on your behalf. So it is important, as you think about that, to recognize that if they are not agreeing to meet the same standard of care, say, and loyalty as you, then there's more risk. Doesn't mean you don't do it. It's just part of the risk-return analysis.
We have a question from Mr. Jones.
Yes.
Yeah, thank you, Madam President. Yes, I thought I heard you, but I would like for you to repeat it. But dealing with confidentiality of information that's being discussed in closed session, and somehow that information is shared publicly. Did you say that that was a misdemeanor on the part of the individual board member?
Yeah.
And/or staff?
Right.
Okay, thank you.
It's the general government code provision. If you don't have a penalty stated in the government code, it's a misdemeanor for violation. Now, whether it's prosecuted depends on the local district attorney with the prosecuting authority, but it's a personal violation of law. It's a violation of law and an institutional violation of for the organization. That's another, but that leads to another important point that I think is worthy of mention, and that is that you as board members hold these privileges and these confidentiality obligations as a result of your position on the board. You as individuals have no authority to waive the organization's privilege. If the board, for example, were to waive attorney-client privilege on something, that has to be a decision of the majority of the board. So a leak of attorney-client privilege is an absolute violation of that principle.
Thank you. Ms. Brown.
So I'm new here, so let me go
Could you
back
move
to
the mic a little closer to you? I'm sorry.
sure.
Thank you.
Delegation to manager, so we're talking like an investment manager, like
Yes.
maybe, okay, or a general partner. So why would we delegate without the assumption of fiduciary responsibilities? I mean, why would we enter into that type of agreement? Because you would think we would want to hold people liable for that, so that if something does bad happen, we can go back and sue them for breach of fiduciary duty. Because if we delegate without that, then we don't have that protection. And I know you talked about the risk reward, but boy, that reward would have to be awfully good in order to sort of waive that or give that away in the terms that I don't see. So, and again, this little circular here.
Right.
So.
No, number one, as your fiduciary counsel, I agree that it's very important to get that acknowledgement. That said, my colleagues who do more of the investment negotiation work recognize that there are certain types of oversubscribed funds where you're not going to get into that investment with certain types of demands. And that's sort of the acknowledgement that that bullet point makes. I far prefer that you get it. Would I say that it's maybe in my past, I've been known to say, don't do it if you don't get it. But I think with now 20 years of doing this, I can say perhaps there are situations where the risk-reward assessment may have warranted making a different determination. And it never blew up, so it was okay. I mean, it's always in hindsight, right, that these terms are most important when the deal goes sour and you're suing. That's where you really wish you'd negotiated those great terms. So this is trying to identify for the board and for executive staff some really important points in my view. But it doesn't mean that they necessarily are deal breakers, but they may be the thing that you ask about in closed session.
So I have one more point to that, if you don't mind. So does that mean if we don't get the assumption of fiduciary responsibility with our general partner, that they could in fact, and do in fact, prioritize their own self-interest first? I mean, I know they have obligations under like the SEC regulations,
Right.
but I mean, when's the last time the SEC did something about that?
Actually, the SEC has been quite active. I don't know if they will be in the coming years, but in the past few years, the last 5 to 7 years, they've been very active in going after bad actors. And you do, if you're working with registered investment advisors, they have fiduciary obligations under the Advisors Act and otherwise. So there are other ways you can get to some of these duties. In terms of the self-interest, that is a really tough nut to crack. And you have sophisticated people negotiating on your behalf to try to get you the best terms to try and avoid, if there is anything that is self-interested, it's at least identified as having to be done in a sort of arm's length terms basis. I don't know the nuances of all of your terms of your contracts, certainly, but
Neither do I.
but nor do many, but because there's a lot to tackle there. But my understanding is that you have a very rigorous process.
Okay, thank you. Mr. Lind. Oh, sorry, did you have something else? Okay.
Thank you. I have a question around a different topic.
Sure.
There is a fiduciary legal theory that as trustees, we not only have a responsibility to plan participants, members around the viability of their pension, but potentially around other issues. For instance, that we could reject an otherwise fine investment proposal because it could eliminate the jobs of plan participants. And the theory being, and this legal theory, is that, well, if you're limiting the number of new plan participants that are coming into the fund, you impact the long-term viability of the fund. And I've heard that theory espoused by many fiduciary legal counsel. I want to get your opinion on it.
The theory is that you should look to whether or not a particular investment is helping. Could you repeat that again?
The example would be if an investment, I guess you could use an example, I don't know, private prisons, all right? Let's say that we want to do some private equity deal around private prisons that would result in the elimination of state workers' jobs, of pension participant jobs, that we as fiduciaries have a role in avoiding that scenario. I'll give you another example. I was the chair of a pension fund for a long time that represented retail grocery workers. We never would invest in a private equity fund or any sort of fund that had Walmart, because Walmart, the success of Walmart meant the elimination of jobs for our members at Safeway or Adronicals or whatever. And we were told by our fiduciary counsel that's certainly within our purview as fiduciaries. So those are the examples of kind of a broader question of that legal theory.
I think you can come at that question from two different angles. One is there are some cases that analyze that with the lens of, that sort of look askance at that. They say you can't prioritize a collateral interest over the success of your portfolio. There are some cases that involve exactly that, union labor, actually. On the other hand, there are some California cases that have said that the Bant case is the one that's coming to mind, the San Diego County Employers Retirement Association case, where the issue was whether the board breached its constitutional and fiduciary duties by doing an interim valuation that resulted in having the employer pay less money longer term through its contribution rates. And one of the arguments made had to do with jobs, and that it certainly wasn't a violation of fiduciary duty to do something that helped maintain jobs, because people don't get pensions if they don't have jobs. So that link has been made in some cases. I don't know if I certainly can't tell you that every court is going to see that through the same lens, but there are fiduciary arguments that could be made on both sides.
Thank you.
Welcome. In terms of the record on investments, there's been a discussion about confidentiality. Well, there's a lot of confidentiality about this. There are also ways in which organizations transmit important information. And so that may be from your outside counsel to your general counsel, describing the terms, the negotiations, where you've ended up, that the CIO may see. And that's the type of record that, at least for internal purposes, you can go back to and say, okay, well, the prior board, or we made this decision, and here were the rationale for doing that, and now let's think about it, either as a learning exercise or because we're being sued. Mm-hmm. We've talked about this quite a bit already, but I'm just identifying it on this slide specifically, or calling out the role of the board, which is typically boards are described as policy-making boards. You set the asset allocation as a board. You determine a level of risk tolerance, the types of investments you do or don't want to get into, but then you delegate the execution of those principles or those mandates to others, to your CIO and his staff, to your CEO and her staff as pertains to the issue. Role of in-house and outside counsel, we've talked about that. Typically, if you're using outside counsel, they're the ones who are doing the heavy lifting on the negotiations, but it's always in consultation with your in-house counsel. Recognizing that conflicts have to be addressed and resolved, and you have a very robust compliance division, and I'm sure are very careful in monitoring personal interests of those who work for you. This comes up with, for boards though, when you have a smaller system that is unable to delegate as much, and so the board members are actually making the decision-making, the way that making the investment decisions, similar to the way that your investment office does here. And if they have what's considered a material financial interest, which is $2,000 or more in a particular stock or bond, they are disqualified from participating in investments with that manager. So that is a very low threshold for a lot of people in this business, and just should be recognized. And I identified some informal assistance that I actually sought and got recently on this topic there. Again, back to this personal financial interest or institutional interest. Certainly, if you are, if in your day job, you are working for an organization that is seeking to contract with the retirement system, that doesn't work. You can't do that. That's a 1090 violation. There may be other institutional interests, though, that you have to be wary of, where you have sort of have a foot in both sides of the negotiation, and that's not acceptable. Similarly, if you have a personal financial interest in any particular investment as defined by law, then you'd need to recuse. All right, so the next challenge, private fund disclosure of fees, expenses, and returns. That was a topic I mentioned earlier. We have different components to this. We have the state legislation that mandates a certain level of disclosure that all retirement systems in California are working to comply with now. You have the institutional limited partner association fee reporting template, sort of trying to get in and help identify, create standards to comply with these reporting requirements. Fund documents, we've talked quite a bit about this, but everyone is struggling with this across the country. So this is not something that people, and nor is it something that institutional investors are tackling alone. There is quite a bit of benefit to be gained from the work of the ILPA. They're developing model subscription agreements, model investment limited partnership agreements now, and those may end up benefiting all retirement plans. I just had a question mark on best practices for annual public disclosures. We're beginning to see what the disclosures look like, and we'll continue to assess what best practices may be. Different topic, another challenging topic of fiduciary compliance, which relates to the setting of your discount rate, your assumed rate of return. So you use an assumed rate of return. There was a discussion a few years ago. It seems to have died down a little bit of cost versus value, with the financial economists urging a risk-based, risk-free rate. That conversation seems to have gone down a bit now, with people recognizing that you're using a actuarially based long-term rate of return for public retirement systems. Very important roles and distinct roles for your actuary, your investment consultant, and your legal office, who need to work in conjunction with one another, but they have different ways in which they look at data, time horizons, and but it all comes together with respect to this particular topic. Asset allocation, this board is very, very familiar with all of these principles, I think, but it was worthy of a slide. Measuring investment risk. All of this implicates your fiduciary duty. All of it is challenging, but that you need to consider the different aspects of it as you reach your determination about what's appropriate under the circumstances. What is the role of your actuary? I mentioned earlier the importance of grounding the decision-making that you're doing in the expertise that guides the topic being presented. So with respect to the setting of your discount rate, certainly your actuary's recommendation is enormously important. You have other in-house staff that are helping pull together the material for you so that you can be sufficiently educated on the options and the considerations. You have your outside investment consultant who will be weighing in on one aspect of this consideration, in-house outside counsel as well who may potentially weigh in. And then the role of the board is really important here too. The California Constitution says that you have plenary authority and exclusive, plenary and sole authority and exclusive fiduciary responsibility over actuarial services, which gives you a lot of authority in this area. On the other hand, you have certain statutory limitations on your authority in actuarial matters, and you will have industry determinations of best practice. And all of that is really important to consider and to take seriously.
Mr. Jones.
Could you expand on those limitations that you made reference to?
Within the PEARL, there are certain provisions on maximum amortization periods, for example. So you cannot go beyond those. There will be rules around how your member contributions have to be calculated so that the members are paying at least 50% of normal cost for purposes of for PEPR employees, PEPR members. Let me think of, not sure if I can come up with other examples.
In other words, these are the rules that we already abide by. I was thinking you would.
Oh, no.
Okay,
as far as I know, you're abiding by
okay.
all of them.
Okay.
Yeah, as far as I know, you're abiding by all of them.
It's important.
But there are there's some evolution in this in terms of principles that that actuaries are looking to, like the California, the CAAP, the California and National Organizations of Public Plan Actuaries, where they are assessing risk and funding levels and how that should all be considered in the context of setting your methodologies. That relates more to methodologies than your discount rate. But there's a discount rate discussion certainly going on. And there will be different issues relating to terminating employers, of course, or those who no longer have active employees versus those who are in a different circumstance. So your statutes deal with some specificity on a few of those issues, but usually it's very general guidance, and so you have to look to your actuary for recommendations. Did that answer the question sufficiently? Okay.
Thank you.
Turning back to investment decisions and the monitoring role that you have as fiduciaries, it's important that you engage in this fiduciary challenge of managing your investment portfolio, not only at the inception of your investments, but also as they continue. Pre and post-close of the investment, and then as the investment proceeds. And there have been some cases, the Tibble case is the most well-known one, U.S. Supreme Court recent case, where the court concluded that the fiduciary duty to monitor continues and has to be addressed through the duration of an investment in order to comply with your obligations. And if there are changes in a particular investment and you are able to modify, tweak, get out, whatever you're permitted to do, you need to examine those options.
We have a question, Ms. Hollinger.
Yeah, thank you. Regarding with going with the recommendation of the chief actuary, well, a lot of times we're also taking into account like what our stakeholders can afford. So there may be a disparity between the discount rate that the chief actuary recommends and maybe what we think is realistic in terms of affordability of our stakeholders. In the event, do we have to document why we don't? Why, if we, let's say, just hypothetically, they said something like 6.5 or something lower than we're currently at, but we realized after talking to our stakeholders they couldn't afford that. They couldn't afford the increased contributions, and there would be financial repercussions to them. Does that have to be documented?
The more documentation you have to support that conclusion, the better, because what I'm hearing from a fiduciary perspective, you to be saying, is that the soundness of the plan in the sense of can your employers actually
afford
pay for it,
right?
may be compromised if
Correct.
you too radically increase their costs at one time.
Right.
And so one doesn't, usually often an employer's complaint of financial woes are not given a whole lot of credence by courts in many circumstances. They're required to pay up for the benefits that they've promised. On the other hand,
but then you create systemic risk, because to the extent that they file bankruptcy, that is systemic risk.
Absolutely, and that's the response.
Yeah.
The response as a fiduciary is that you are minimizing that systemic risk by moderating the time period over which you collect those contributions, because ultimately the contributions have to be paid, because that's...
No, I'm not disputing that.
Yeah.
I'm just disputing because we do get from our there is obviously, with what we think. It's a balance.
It's a balance.
Right.
The ideal circumstance is for your actuary to incorporate sort of a holistic view of the goal, so that collectively you are considering those various factors. Because it is everyone's goal to make sure, or it should be everyone's goal, to make sure that the system is funded in a manner that will make sure that those promised benefits are paid on time. Now,
I'm just trying to protect us as fiduciaries if the actuary recommends one thing and for these other reasons we don't follow it. I just, for the record, and to know that.
I think what I'm hearing Ms. Dunning say is that, one, is that we should encourage our actuary to incorporate those risks into his own analysis, and two, that we should document and set a record about the rationale behind our decision making.
Right. And it may be that your actuary disagrees with your assessment. So that, I mean, and that, he's not to be a rubber stamp either for certain directives. So, but the conversation needs to occur with the eye on the ball, which is duty of loyalty to the members and beneficiaries. You're not in the business of making sure that the employers are able to pay for other things, but you are in the business of making sure that you're getting your required contributions, and that those contributions are going to be able to pay the benefits that they have promised, or the legislature has promised to their employees. I mean, that's why this is a challenge. This is.
Yeah. Okay. Thank you.
Okay. Investments, again, the investment consultant's role. So recognizing potential conflicts of interest. We've already touched on that a bit. I'm sure you're all very aware of that issue. Investment staff has a very important role at CalPERS in terms of the implementation of your policies. And the board's role is more one in which you receive information, you provide policy level guidance, there may be exception reporting, there may be certain things that you talk about in closed session that are important to you as a board, where you say to your advisors, if there is going to be an agreement that we enter into that doesn't have X term, we want to know about it. Give us an opportunity to make a different decision. There's always this challenge between having boards remain policy level. It's the nose in, fingers out concept, so that you allow your executive staff to do their jobs, but that you feel like you have provided sufficient guidance and sufficient monitoring so that you are doing your jobs as fiduciaries. This is the slide I needed to call my partner about this morning because I couldn't remember she's the investment person. I couldn't remember all of the points we were making here. But here in the private fund negotiations, there are some issues that have come up recently relating to communications with other LPs. My understanding is that some of the general partners are really pushing back and suggesting that limited partners shouldn't communicate with one another, whereas the LPs are finding an enormous amount of value in communicating with one another and don't see legal impediments to doing so. There's a lot of discussion over economic versus non-economic terms. Your investment staff may be focused more on the economic terms. Your legal staff may be focused more on the non-economic terms. Reconciling those is a challenge, but important to do. There are certain highly contested provisions that we're seeing right now in the market, without getting into too much detail. But on the latest GP strategies and LP pushback, there's a lot around fund expenses and allocation of fund expenses where the GPs are trying to push those onto the LPs. There are attempts to push indemnification obligations onto LPs. There are, the market terms will vary by class. So you'll see in some of the oversubscribed venture funds a very different sort of negotiation dynamic than you might see in other asset classes. With respect to the role of the LPACs, the limited partner advisory committees, there's a discussion about in-camera meetings. Shouldn't the LPAC members be able to meet without the general partner and hire third-party advisors in order to audit, provide legal services without the intrusion of the GP who they're actually looking into? Or if there's some cap on expenses in that context to make sure it's high enough they can actually do their job. So there's a lot of sophisticated negotiation going on around these issues to protect the limited partners. And this is all a way of helping you as fiduciaries comply with your obligations, because those obligations apply to the whole, really to the whole organization. Okay, that was the one I needed my cheat sheet. Okay, so sources of interpretation of fiduciary duty. Where am I going to get this guidance? We have our state constitution, of course. That sets out in Article 16, Section 17, these responsibilities and authority. Case law, which is developing. I started at that point, and we're continuing to see case law develop in some of these areas, and we'll continue to, given the amount of litigation that's going on right now. ERISA does not bind CalPERS, as you know. It does not apply to governmental plans. However, that is where we see a whole lot of law in these areas, in this interpretation of fiduciary duty under ERISA. So we do look to it for guidance. We also look to Department of Labor advice letters for guidance and case law. So that was my presentation on fiduciary challenges in an evolving legal landscape. I've added to this presentation, though, a discussion of a development in the European Union that I understand there's some interest in. And so I'll do my best to provide sort of a high-level view of what I understand to be occurring in that context right now. The preface to this is that this neither binds nor protects the CalPERS Board, because it applies under laws that govern European Union members, not the United States, and certainly not California pension plans. But it is very interesting. So a year ago, just over a year ago, the European Union issued I believe it was the European Union, issued a European Pensions Directive, which directed EU members to place a consideration of ESG factors at the forefront of their investment decisions. And in that directive, they were looking to modify the definition of prudent person to specifically incorporate ESG factors. There are various groups, as you know well, from this offsite and earlier presentations, as well as prior discussions, I'm sure, that there are a lot of organizations weighing in on this topic. And one of the recommendations that came out in a report by the high-level expert group on sustainable finance, recommending that the European Commission clarify that fiduciary duties of institutional investors explicitly integrate material ESG factors and long-term sustainability. So that was their recommendation. So what's happened since? There's a public comment period. The EC launched a public consultation period in last November, and the comment period is open through the 22nd of this month regarding this topic, evidence from leading responsible investors on their strategies for considering ESG issues. I've included a report here that you may be familiar with on this topic, and then I've added a cautionary note to all of you, which is that regardless of the evolving definition of fiduciary duty globally, CalPERS is governed by state law. Common law principles of fiduciary duty regarding your administration of the plan and your investment of assets, and that's what you live by. And so that does continue to require that you maintain your eye on the ball of maximizing return, minimizing risk, not subordinating those interests to collateral objectives. Doesn't mean you can't look at it ESG, doesn't mean that you have to look at it askance, but you do need to keep your eye on the economics because that's the fundamental responsibility of this board. That's my final slide, and I'm happy to take further questions.
Thank you. Ms. Taylor.
So I will just, I really appreciated that you added the ESG strategy in there, and I always appreciate your fiduciary training. I will just say that as we look at ESG strategy, we're looking at long-term sustainability of the fund. We are looking at it fiduciarily. We're not looking at it as a collateral issue or anything like that. So,
absolutely. That's great.
So I think we need to make sure that, you know, as we introduce this, and I think I talked about this on Tuesday, is that we're also conveying that to the public so that we're not putting ourselves behind any kind of 8-ball, but I think that we need to be conveying that to the public because it is long-term risk, and actually it can be even considered short-term when you look at the weather right now. So,
Absolutely. It is important that you continue to make those observations and to live by them.
Any other questions from the board? Mr. Miller.
Thank you. I guess my question, I'll try to see if I can articulate this in a coherent way. I understand the concern about not subordinating our primary fiduciary responsibilities to these collateral interests. But to the extent that particular decisions have indirect impacts on other investments that may actually be more significant than the potential return or risk balance for that particular investment or investment class, how does that fit in versus this idea of collateral, interests when they're indirect, kind of not so obvious, and maybe not even part of the collective current wisdom on something that may not be so obvious?
That's a fascinating question. I think that's a really big picture approach to the topic where you're looking at investment considerations in sort of a global portfolio way as opposed to one by one. And that would be a wonderful question for your investment consultant or your CIO or both as you're considering these matters. I don't, that's certainly not out of bounds in my book.
Thank you. Any further questions? All right, I'll turn it back.
I just had a comment on
please.
ERISA because Ashley kind of touched on it, but I think it's worthy of a little bit more thought, which is Ashley's absolutely right. ERISA doesn't apply to state funds, but ERISA says a lot about fiduciary duty in the context of what you can and cannot consider, and the Department of Labor has said a lot in that context. And we would be, we should be, in my view, careful to disregard that, not because it doesn't apply to us, but because there's an effort out there in Washington and at various other places to make state funds regulated by the federal government. And to the extent that we ignore ERISA and the laws that have come down under ERISA, we increase, in my view, that risk that the feds would come in and say, hey, there's a rationale here, they're not following prudent practices or what have you. And so I think I just would point out that it's worthy of considerable thought as to where we are on ERISA on any particular issue.
Thank you. Ms. Hollinger. Yeah.
And just for the record, I do agree with that. I think that's really important observation.
Thank you.
Yep. My concern, where you said our fiduciary duty is maximizing return, minimizing risk, and now in the board we're hearing from certain counties, police officers, et cetera, because sometimes they're on the ESG, they want us to be more focused on returns. So how do you allocate resources and priorities, being as we're fiduciaries to all, we have a limited pool of resources and staff. How do you balance that?
Ultimately, the buck stops with the board. So you as a board need to make your assessment, your prudent assessment of where you allocate resources in consultation with your executive staff. And the fact that you get input from your members and beneficiaries and other stakeholders is really important, but it doesn't mean that you should make one decision over another.
But if I were in a business and I, let's say I would be at 68% funded, I would, I would know that I'm in dire straits, and my priority would be obviously on the funded stat. I mean, I get concerns making sure everybody's got their eye on the ball, and we're not focused on the long term and ignoring the short term. But believe me, I believe climate. Why? I believe all those are long-term risks. Like Teresa said, climate may be a very short-term risk.
Thank you.
Not sure if there was a question in that or if that was a comment. Yeah. You are in a long-term risk assessment environment, notwithstanding your current funded ratio, which differs from a private organization because you do have a state that is the ultimate guarantor of benefits to the state employees, as well as the public employers who are the guarantors as to the contracting agencies. Doesn't mean that you don't keep your eye on that ball, that funded. You have to make sure that you're continuing to collect the contributions that are going to pay the promised benefits, which gets back to the earlier question about, are you charging the employers too much? That's another challenging path to go down with the ESG discussion of long-term returns and risks. That's it's an important discussion, but it has to be moderated in a way so that you're not sort of veering off the track, but you're keeping your eye on the economic responsibility, as Trustee Taylor noted. Same thing with the employer concerns about their budget. That conversation also needs to be moderated.
Thank you. Mr. Miller.
I think my question was very similar, and I think you've mostly answered it. But it's that from our fiduciary perspective, when we've got these different continuums of risk, return, and then the time element changes the whole balance. And as fiduciaries, any thoughts on how that impacts when we look at these time horizons for our planning and the urgency of some of those collateral issues that we're also pressured by with our members and some of our constituencies, some of the local governments, for example. How do we have those issues in our consciousness but still make prudent fiduciary responsibilities when we've got those three big variables writ large, and there's an argument to be made on either side of all of them? it's almost more rhetorical than
Yeah.
here's the
No,
answer.
I mean, it is rhetorical.
know.
I guess I'd have one observation, that you are, you're intended to be an actuarially funded system. And it's really important to think about how you fund the system in a manner so that you can meet the actuarial soundness requirement, which most actuaries will say, I don't know what that means. But it is a legal requirement, and it's in a bunch of cases that say that members have a vested right to an actuarially sound system. So what do you do to get there? What you don't do is extend your horizon so far, so make it so long that you are both increasing the long-term cost and decreasing your realistic assessment that you're going to be able to fund the plan. And so, when you talk about concepts that, again, are not binding on you, but they're informational, they're instructional, intergenerational equity is one of those, where current taxpayers are paying for current services that are being provided to them. Those are guiding principles that your actuary is also looking to help you make decisions that in the end will make sure you comply with your fundamental job. Welcome.
Well, thank you very much, Ms. Dunning. I don't see any further requests to speak. I think this has been a really substantive and interesting conversation.
Good, I'm so glad. Great questions, and thank you for having me.
Thanks very much. Well, that brings us to the end of our agenda. Thanks, everyone, for being so attentive and engaged. Sorry?
Do your survey.
Yes, and please do your survey. Thanks so much. We're adjourned.